I'm excited about this story because it took me down maybe my favorite rabbit hole of the week, and it involves Hawaii. And there is a lawsuit that was going through the legal system in Hawaii, and the decision that was just released by the Hawaiian Supreme Court, it has to do with church-state separation, and it really offers a rebuke to John Roberts and what he has done with this Supreme Court, the US Supreme Court. So let me try to explain what the hell this case is even about, because odds are you have not heard of this case unless you read very niche articles on various websites. Anyway, okay, here's the story as best as I can understand it. In 1922, that's how far back we are going, over 100 years ago. In 1922, the governor of what was then the territory of Hawaii sold a roughly 4-acre plot of land to a guy who was a trustee for the Mormon church. He sold it to this guy for $20 back in the day, which I'm sure was a ton. But their contract, I will show you a little bit of their contract, and check this out. This is what their contract said at the time. The land covered by this grant is to be used for church purposes only. In the event of its being used for other than church purposes, this grant shall become void, and the land mentioned herein shall immediately revert and revest in the territory of Hawaii. So you understand what that means. We're going to sell you 4 acres of land for $20, and you got to use it for church purposes, which makes sense because the guy who's buying this is a dude who works for the Mormon church. And they said, as long as you use it for church purposes, we're good. But if you stop doing that, we get the land back. It's ours now. Okay, so that land patent said it had to be used for church purposes only. And the thing is, if you go on Google Maps and you look up that plot of land, as I did because I got very bored one day, it's definitely not a church. It's just an intersection. It has not really been developed into anything. I mean, it's only 4 acres of land. It's not that big, relatively speaking, but it's not a church. And the thing that happened is that right now it's vacant property, but over the course of the 100 years, this land got bought and sold by various companies. In 2000, that land was sold to a company called Hilo Bay Marina LLC. And in 2015, one of the parcels of that land was sold to a company that sounds like a religious group, but it's not. Basically, both of those companies, the land is entirely owned by the same guy whose name is David Owens. So he's this random guy who has all 4 acres of land, and they're his. And he has his businesses. He wants to use the land to promote his businesses. Yeah, that's how buying land works. There's nothing weird about this so far. But in 2022, David sued the state of Hawaii. And what he said is that basically he wants to develop this property into stuff for his businesses, but he's not allowed to do that because the grant, the land contract that he has, says he's only allowed to use this land for religious purposes. And he's like, but I want to build my store. And they're like, you can't do that because that's not a religious thing. And his argument to the court was, the state cannot force me to abide by this religious restriction. And the fact that it even exists in the contract is a violation of the Hawaiian Constitution and the US Constitution. His lawyers even said in one of their briefs, the Supreme Court has, in no uncertain terms, repeatedly confirmed that the Establishment Clause forbids both state and federal governments from aiding all religion to the exclusion of non-religion. So they're saying this has nothing to do with the Mormon church. You're saying we got to use this land to promote religion. You can't do that. And the Supreme Court has said, historically speaking, they have said you cannot say, the government cannot say pro-religious stuff at the expense of non-religion. They can't take a position on religion, much less a particular one, right? Okay, so what the state said in response to this lawsuit is the contract the guy has is fine. You cannot sue us as a state because that contract is tradition. It's totally what we did back in 1922. They called it a primitive form of zoning, and so it's still valid. They would never do it today, of course, but back in the day, that's what we did. It's tradition. The US Supreme Court likes tradition, so we're fine. And then they added the state. The state says there are plenty of laws that have its roots in religion. For example, I talked about this a couple weeks ago. There are some states with blue laws. And those are laws that say you can't like sell alcohol on a Sunday because that's the day of rest. That's the day you're supposed to go to church. You can't even you can't even open up your retail store on a Sunday or a Sunday morning because that's when people have to go to church. And so the state of Hawaii is saying, see, that has religious roots, but we allow it to stand today because it's always been like that. Now, what did David's team say in response? They said, what are you talking about? The blue laws, even if they have historical roots, they exist today because you can still make a secular argument for them. For example, Sunday is a day of rest for everybody. That's why a lot of places are closed on Sunday. They're not doing it because you got to go to church. So they argued there is the restriction at the center of this contract that you got to use the 4 acres for religion. That has no secular justification, so it should be illegal. Okay? I hope I'm explaining this well. So this goes to court, and the district court judge basically says, I'm going to side with the state. The deed restriction is legal, and the original agreement is secular. You could argue it's secular, the judge said, because it allowed for any religious group to benefit from the property. It didn't say you can only build a Mormon temple on this land. It said it had to be used for religious purposes. So there's no discrimination here. There's no violation of the Establishment Clause because any religion will do. You want to build a monument to like atheism, the judge is implying, you can do that too. But that kind of misses the point. And so that decision was appealed. And the Hawaiian Supreme Court's like, you know what? Just skip the middlemen. Give us this one. We're going to weigh in on this instead. And they decided to take the case up directly. And the Hawaiian Supreme Court issued their decision this month. And this is kind of amazing. Let me pull this up right here. Because in their decision, look at what they said. Here we go. This is what the Hawaiian Supreme Court said in a 65-page ruling. Moreover, enforcement of the deed restriction is not a neutral act between religion and non-religion. Rather, the deed restriction explicitly favors religion, requiring any owners of the property to continue using it only for church purposes or they will lose the property. So, like, you can't do it. This is a unanimous decision from the Hawaiian Supreme Court, and that's wonderful. They basically said that contract that the dude signed, it violates Hawaii's Establishment Clause, so you can't have it. They also said it's ridiculous to consider the tradition of what contracts we were going by in 1922. We can't consider historical practices because Hawaii wasn't even a state back then. And they said Hawaii's constitution went into effect in the 1950s because that's when they became a state. So, like, if we want to look to tradition, we want to go back to like what the founders said when our state was established. Well, then you got to go all the way back to the 1950s. And guess what? They were pretty explicit about the Establishment Clause and church-state separation. So let's go by that tradition, shall we? They basically said in this thing, and this did make me laugh when they said it. Check this out. Right here. We reject that notion because the record in this case, discussed above, does not support the state's contention that church purposes deed restrictions were part of an early form of use zoning in the territory of Hawaii. Further, there is nothing in the record to indicate that the framers of the Hawaii Constitution or the electorate considered such state actions as consistent with the Hawaii Establishment Clause adopted in 1959. So, beautiful result. They strike down that contract, and that's great news. What it means is that this property owner, David, he doesn't have to follow the religious use only. You can use the land for whatever legal thing you want to do, and we're just basically going to ignore the whole church use only thing. That's great. That is good news. That is not why I am telling you this story. Do you like that wind up? That's not why I'm telling you this story. I am telling you this because even though the Hawaiian Supreme Court wrote that 65-page decision, there was one judge who's like, I agree that that church use contract is a violation of our Constitution. I agree with it. The decision is right. But you know what? I have more to say about this, and I'm going to write up my own concurrence and tell you why I think this guy, David, is right. But it's separate from it violates our Establishment Clause. He wrote his own concurrence. It is 40 pages long. And I just want to point you to this Slate headline. When they read this concurrence, look at what the lawyers at Slate said. This is the most withering indictment of the Supreme Court ever by a sitting judge. They were not talking about the Hawaiian Supreme Court decision I just showed you. They were talking about the concurrence written by one of the justices as an add-on to this decision. So the judge's name is Todd Eddins, Eddins. And oh my God, there is so much good stuff in here. It is freaking glorious. Are you ready for this? I'm going to take you through some of this. I'll take you through as much as I can of this. But basically, Eddins denounced what the John Roberts Supreme Court has said about religion over the past several years because he says church-state separation is so damn important, but the U.S. Supreme Court keeps trying to ruin it. Oh, there's so many delicious passages in here. So here's the thing. He says, I wanted to write this concurrence because our Hawaii's Establishment Clause has a pluralistic purpose and secular spirit grander than what the majority suggests. Look at this. As jurists, talking about judges, as jurists have long known, and as the people of Hawaii who ratified our state constitution over the years understood, the promise of religious pluralism and secular government depends on a durable wall separating church and state. Without it, religion, government, and civil society suffer. He's just getting started. And then he says, Hawaii, when it comes to how should we interpret the Establishment Clause, we should not be taking cues from the conservatives on the U.S. Supreme Court. Let's just look to our own Constitution and things like that. Check this out. If the Supreme Court decides a case based on mission, text trickery, originalism, or imagination, then that case may have little value to a state that prefers a more principled way, or an interpretive approach that does not force contemporary society to pledge allegiance to the founding era's culture, realities, laws, and understanding of the Constitution. Oh my God. He's slamming the conservatives for trickery and their supposed originalism. Like, why are we asking the conservatives on the U.S. court to say, what did the white founding fathers say about church-state separation? Why are we depending on Clarence Thomas's interpretation of what a lot of those secular or deistic founders said, when in Hawaii, our church-state separation is way stronger, and we could just be looking to ours anyway. Then he goes hard at Roberts. Check this one out. The Roberts Court casually dismisses the lessons of American and world history, the warnings of prominent early Americans, and the judiciary's storied legal minds. Bad things happen unless government and religion are completely separated. Oh, he's not done. He keeps going. The court, talking about his court, I believe. No, sorry, the U.S. Supreme Court ditches neutrality and boosts accommodation over the wall. It flirts with the true harms the framers foresaw: coercion, exclusion, and civil strife. It invites state involvement with religion, and it exposes minority faiths and non believers to majoritarian impulses. Whew. Oh my God. So this guy goes on to describe, Judge Eddins describes so many of the church state rulings that the U.S. Supreme Court has issued and how they created these holes in the wall of separation. And he even says here, let me see if I could pull this one up. Look at what he says right here. Now the government must equally treat secular and religious entities in public funding matters, even when taxpayer money directly supports religious indoctrination. He's just going after everyone, all their stupid decisions. It's fantastic. Here's another section. Here we go. We're on page 28 of 40. Taxpayer funds now flow to religious institutions. So the government collects money from non-believers under the threat of jail, because you got to pay your taxes, and uses some of it to support religion. And since not all religions will receive public funds, the government forces minority faiths to support other faiths, or else. The court twists text, history, purpose, precedent, and public meaning to offend the First Amendment's character of government structure and the Constitution's separate sovereignty structure. There was one more section here I wanted to show you. Look at how he ends this thing on page 29, just this section. Today's court often rules not because the Constitution says so, but because partisan preferences and personal values say so. Oh my God. So this guy really goes for the jugular when he talks about Joe Kennedy, who I mentioned earlier, who was that high school coach who wanted to pray at midfield after games, even though he was on the clock and working for the public high school. And the Supreme Court famously, they sided with the coach, but when Neil Gorsuch wrote that opinion, he lied about all the facts of that case. He said the coach was fired. He was not fired. He said these were private prayers. They were not private. Sonia Sotomayor, in her dissent, even said, oh, here's a picture of him praying silently, and there's a giant mob around the guy supporting him. And so he goes after that particular case because the Supreme Court lied the entire way through. Here we go. Here is that section about the Kennedy case. We're on page 33. History is prone to misuse. The current court shrinks, alters, and discards historical facts that don't fit. It handpicks history to make its own rules, missing the broader context of a constitutional provision's original and contemporary purposes. There was one more section here. Let me pull this up for you. And this is on page 38. Same basic section. Look at this. Pretend law based on pretend facts and unsound methods has no place in Hawaii law. Unbelievable. Last little bit I want to share with you. He says when it comes to this case in front of him, this is, by the way, Todd Eddins, Eddins, and I will show you where is this right here. I will highlight this for you so you could see it. This is from the Slate article, Justice Todd Eddins. But back to what he was saying in that little bit I was showing you. For the reasons stated in the well-done majority opinion, which he signed on to, a deed restriction imposed by the state that requires a landowner to use land for church purposes only, or else it reverts to the state, constitutes state action that advances religion. Look at this. The state's purpose in retaining a reversionary interest is not secular. It's religious. The government does not just accommodate religious practice as a condition of property tenure, it forces faith-based use of the land. It conditions ownership and land use on the advancement of religious activity. The state compels religious use and excludes all secular purposes. It favors religion over non-religion. And he says, we have a classic violation of the Establishment Clause. And then this, we're on the final page here. Look at this. Let me explain what he's about to talk about. When John Roberts was getting confirmed to the Supreme Court, he basically said during his confirmation hearings that my job is to call balls and strikes. I'm not here to change like the strike zone. I'm just the umpire. I don't make the law. I just apply the law, right? So he calls balls and strikes. And this is what Judge Eddins says. Back then in the big games, the Roberts Court called balls and strikes based on the pitcher and hitter. Bad enough for the integrity of our judicial system, national and subnational. But now, pitches that bounce to the plate or sail over the catcher's head are strikes, just because the ump says so. Pretend law is not law. State constitutionalism makes it easy to consider Roberts Court jurisprudence white noise. Signed, Todd Eddins and his team. Unbelievable. So this guy's basically saying, look, Hawaii's constitution is awesome. Let's interpret the Establishment Clause. Let's protect separation of church and state. That's why we're ruling in favor of David, who can use the land however he wants. But since this is a church-state separation case, let us not look to whatever the hell John Roberts and the U.S. Supreme Court is doing, because they have no clue what they're doing, and they are distorting the law to meet their religious partisan goals and not actually doing their job. Incredible. Going back to that Slate article for just a second, because I respect the journalists who write that, this is what they said when discussing this concurrence. Justice Eddins didn't leave anything on the field. He is saying what nobody else, at least in the judiciary, seems able to say about the Supreme Court right now. To which the other lawyer responds, and also, no lies detected, right? So really, really amazing. I mean, this is not about like a 4-acre parcel of land in Hawaii. This is about the integrity of our democracy. Justice Eddins, his scorching indictment of the Roberts Court, it just underscores how far the Supreme Court of the United States has drifted from the founding principle that the government's supposed to remain neutral on matters of faith, because they have destroyed church and state, the separation between them. They have betrayed their duty. They have left minority religions and non-religious people vulnerable to coercion and exclusion and forced subsidization of beliefs they don't share. But thankfully, Hawaii's justices here are reminding us that constitutional law isn't that complicated, and you don't need to twist it to achieve the right results. Sometimes the answer is totally straightforward and obvious, and yeah, it happens to be secular. And I am so appreciative that this justice is like, I'm calling out the bullshit coming from the United States Supreme Court because of its religious favoritism, because it is bending the facts, because it is trying to rewrite history, because they're cloaking their obvious partisan ideology in legal terminology to help conservative religious wingnuts. It's judicial malpractice. So this is good. This is why it's so important to have good state courts as well, because while the U.S. Supreme Court is trying to erode church-state separation, you do have some judges, including federal judges, like the ones who have struck down the Ten Commandments laws. Like, there are people who will choose principle over politics, and they are doing the right thing, and they deserve applause when they do things like this, and they deserve attention for it when they do things like this. So I just wanted to bring that to your attention, because I mean, I'm not a lawyer, but man, it's fun to read that concurrence. I'll leave a note if you're watching this later on in the description below. All right, what questions we got here? Wow, pulls no punches. No, he does not. It's glorious. If the contract is void, does that mean it should go back to its original owner? I mean, according to that contract, if it was void, it would go back to the state of Hawaii to do whatever they want to do with it. So it's not going back to like the Mormon trustee guy because he sold it, so it's not his anymore. MAGA will just call this judge an extreme left-wing woke judge. They will, and of course, none of those words mean anything. And we got to get used. I wish elected Democrats or Democrats who were campaigning stopped getting worried when they call you out for being woke or when they call you out for being left-wing. There are better responses to no, I'm not. Like, so what? I'm proud of defending the Constitution. I'm proud of defending the founding fathers' intentions. And I'm not going to like change my values just because religious wingnuts want to do it that way. Why can't they have a bigger spine and say what this judge is saying? A lot of Christians, I don't think, know the difference between secular and atheist. Fair point. I mean, I am not asking the government or the courts to endorse atheism. I'm not asking them to promote atheism. That's my job. But they do not have the right to tell anyone what to think about matters of religion. When we say they should be secular in this context, we're just saying the government should not say the land has to be used for religion, just like it can't say it has to be used to promote atheism. Just say you get to use the land. It's yours to do what you want. That's secular. That's neutral. Again, this is the argument you sometimes hear from the Christian right, which is when we teach evolution in schools, that's promoting atheism. No, it's not. It's promoting good science because that's how science works. Just because it overlaps with what a lot of atheists believe doesn't mean it's promoting atheism. We all just happen to live in the same Venn diagram where reality is, and those people don't. You know what I mean? So in this context, secular just means neutral. The government, people can have their beliefs, but the government should not be promoting any one particular belief system. That's secular. And I know it sometimes gets confusing because atheist groups sometimes use the word secular to describe themselves, but different context here.